right, well, good morning, ladies and gentlemen. We'll go ahead and get started. We are missing a few post-council members. Chief Carpenter had a conflict with court, so he's been excused. Commissioner Gibson is running late. I assume the same for Sheriff Edmonds, Chief Burbank, and Dr. Checkett, so we'll bring them up to speed when they get here. At this time, I'd like to have the minutes from the September 24th meeting approved. We can get a motion. Thank you, Mr. Austin. We'll have okay. Second by Sheriff Tracy. All in favor? Aye. Okay, great. Turn the time over to Lieutenants Acosta and Brewer now for quarterly reports.
Good morning, council members, distinguished guests. Just to give you a quick report on what has happened since our last council meeting, we have received a total of 22 complaints received in the investigations office. Of those, all 22 were opened, and an additional one, for a total of 23, were opened from a previous complaint that we hadn't received all the data on. We have conducted one administrative hearing. We have closed 5 cases with no action. We have had 5 voluntary relinquishments. Of the 5 voluntary relinquishments, 2 have been sex on duty. 1 has been a BCI violation, 1 falsifying government records, and 1 lying under Garrity. We have a total of 162 background investigations that we've conducted. We have 64 active investigations with a total of 109 investigations that we're still looking at in some stage of investigation. Any questions for the Investigations Bureau? All righty. Thank you very much.
Thank you, Lieutenant Acosta. Lieutenant Brewer? And the audit, and then legislative items. Scott, just go ahead and go there, and then state accreditation, if you would.
Okay.
Thank you.
Thank you, Chair, Council. To report on the in-service training hour audit that we conduct annually, August 1, we sent out a suspension letter for those officers who were deficient. For those in the room that do not know what this audit is regarding, it's regarding the 40-hour in-service training requirement for continuing education for officers to maintain their certification or license, if you will, to work as a peace officer within the state of Utah. We audit every officer, which are about 9,000 officers statewide, to make sure that they're meeting that statutory obligation. In August 1, we found that 103 officers were deficient and 103 suspension letters were sent out. As of October 1, so we give them a couple months to reconcile and make up the hours before we report to URS, which is Utah Retirement Systems. And on October 1, we reported 23 officers to the Utah Retirement System that are still deficient to this day. So, any questions about the audit? Okay. If you guys recall, last year I had Representative Greenwood run a bill that would add a sanction to the reporting statute. There is a statute that requires chief administrators to report to post any officer that is in violation of 53.6.211, which is the post statute. That was met with some resistance. However, most of the administrators I spoke with agreed with it. But there were some holes and questions that I wanted to answer, and I had Representative Greenwood withdraw the bill for further dialogue and discussion. After speaking with Commissioner Squires and a few other administrators, I am proposing to this council, and what I'm asking for is a vote as to a direction or a course of action you would like me to take. There is the legislative route, which I have 2 drafts that include a Class C misdemeanor as the ultimate sanction if somebody fails to report within 90 days. And then there is a progressive bill that if they failed to report, then they are required to come before the council, this body, and explain why the case was not referred to post. no action be taken, just merely come before their peers and explain why they did not report. And then if they fail to come before the council, then there would be a progressive sanction of a Class C misdemeanor. However, I feel more comfortable if we could handle this by administrative rule. I've been working with Marcus Yockey, our AAG rep, and it does give me gives me a lot of authority to create administrative rule with advice from the council. And we have drafted some language that we feel we can handle with administrative rule, and that would require that chief administrator to come before this body and explain why they did not report the case to post. So I'm asking for a vote of direction, I guess, is it the legislative route or the administrative route? I think administratively would be more, I don't want to say easier, but it would give us a good barometer of what we are looking at as far as not reporting. But it adds more teeth to the current statute. And if we do see a problem, then maybe we can progress in the future to a statutory remedy. So those are my thoughts and opinions of a course of action, but ultimately I will do what this body
So, Scott, under the administrative rule, is there still the Class C misdemeanor?
No.
So what sanction would you be able to take if an administrator simply refused to come to the post council and explain?
With this approach, there would be none. But I believe most of them, if not all of them, would come before this body. We're talking about very few cases. We're just trying to tie up a loose end and show the public that we are accountable at every level of law enforcement.
And then for clarification, the 90-day reporting is just to require the administrator to report an action that they may believe is in violation of the section. It doesn't require the department to have completed their IA investigation, which is a totally separate matter, correct?
The way it reads is if they find it to be true, then they have to report it. So if it takes, some departments don't have an extensive staff, therefore it may take them longer to progress through an investigation such as this, then once it's verified that it did in fact occur, then they have 90 days to report it to us.
Okay, but haven't we had some incidences in the past where some IAs have taken significantly longer?
Yes.
That could literally drag out well beyond a year?
Yes.
So it would be 90 days from the end of when that is finally, so you could be talking 2 or 3 years if somebody wants to drag. I mean, I can't understand why you would want to, but, but that possibility exists for that to take that long.
Feasibly. At the conclusion of an investigation, that's when they would be required to report it to us.
Okay, well, is there any discussion from other members of the Post Council on this? I somewhat see a problem with that. I think that gives an out for somebody. Not that I think that it would happen, as you pointed out, very often, but the potential does exist that it could happen.
Yes. The circumstance that you explained, I believe, would be an anomaly.
Right, but it has happened. So,
yes.
And usually it's a high-profile case where it does happen, where transparency is being called into question anyway.
Yeah.
Sheriff Edmonds.
Just for clarification, Director, if an agency is conducting an internal affairs investigation and that investigation is not concluded because the subject or the target of the investigation resigned, for instance, and therefore the investigation then stopped, those still don't need to be reported, or they do?
No, they would. I mean, just because you don't finish an investigation doesn't mean that you haven't verified that it has happened. You may not have been able to interview everybody, but let me explain to you what happens 95% of the time. An administrator contacts me and talks to me about what the possibilities or the outcome of this circumstance may be. So I work closely with a lot of you to work through some of these cases. We could tie in language that would address your concern that if they just don't complete the investigation, that the case drops. Again, this is a working document, and that's why I'm bringing it before this body, but I do understand your concern if that is the case.
Yeah, it is a concern. If we could address that in the administrative language, I think that would be helpful.
And what I will do, depending on the direction I am given, I'll send out this document to this body and receive feedback, and then I'd like to send it to the Chiefs Association and the Sheriff's Association for feedback as well before any action is taken.
Any other questions for Director Stevenson? Any further discussion on this matter? Anybody care to make a motion as to which direction they would like Director Stevenson to proceed on this? Either administrative rule or legislatively?
I don't mind making a motion.
Thank you, Sheriff Edmonds.
I'm happy to support the director in his desire to want to take this an administrative route, as long as he can make sure that he consults very closely with this body concerning some of the issues that we may or may not have. I'd be willing to make the motion that we go ahead and move towards an administrative remedy to this issue.
All right. We have a motion to move to an administrative remedy. Well, any discussion or questions of the sheriff of his motion? No? Okay. John, you second? Okay. Okay, we have a motion and a second. All in favor, say aye.
Aye.
Any opposed? Okay, motion passes.
Thank you. Next point of discussion is this a state accreditation process, and Frank Budd is well aware of the attempt to create a state accreditation, and this is similar to CALIA, but I think it's a good point of discussion, especially in light of what's going on nationwide, just as a proactive measure or discussion. But I would, at this time, I'd like to ask Frank, sorry to put you on the spot, sir, but explain, you bet. I'm just flying. Just give us an idea of what was attempted, and then we can start from there.
Currently the Utah Chiefs of Police Association does have an accreditation program. Candidly, we have not had many agencies apply. I have one right now that has indicated they are finishing up the process for application. We have a number of standards, several hundred standards actually. Some apply, some do not apply. For example, if you don't have a jail, then those standards are non-applicable. If you don't have motor officers, but generally speaking, they cover just about every area. The standards cover just about every area of law enforcement administration operation. We do not tell an agency what their policy needs to say. We do say you need to have a policy. For example, use of force and pursuits and those kinds of things that draw a lot of public attention. We don't tell you this is what you have to do, but you have to have a policy for it. And frankly, as we go out and do the accreditation visits, it really, I'm going to say forces because it's voluntary to apply for it, but it basically forces an agency to review all of their policies and make certain that their policies are up to standard and timely and these kinds of things. As I've gone out, I'm generally one of those who goes out to make a final a visit, and we find things like insurances that have lapsed and things, it's not minor if you have a problem, but things like that. And but for the most part, most agencies have brought all their standards, their policies up to meet those standards. And I think it's a good program. It's just that we don't have many agencies that have volunteered at this point.
How many?
Half a dozen or so. Yeah.
Question is, are you using a vendor or did you develop your own for the state?
The association developed its own prior to my coming on as director, using a number of other states that have their individual state accreditation. And frankly, our association needs to revise our standards and go back. I've gone through them, and for the most part, they're still in line, but we need to do some of that. Frankly, I haven't pushed the envelope because we have maybe one agency a year that indicates an interest in doing this. It's quite a big job. It's usually assigned to an officer, usually at the lieutenant level or above, and it takes them about a year to get their stuff pulled together.
But it's not as costly as CLIA.
It's not costly at all. Basically, we charge, we ask a fee of about $300 now, and part of that goes for a nice plaque that we give them when they complete that. So all the work we do is basically have agencies that help and they volunteer. So we don't charge essentially for that.
Do you feel like that is the body in which this agenda should be driven?
Well, right now it's the only body that. If you're saying should it be at the state level
Or
at post level, we haven't discussed that, but I suppose it could be there. I think most of the states that have their individual state accreditations, it works back through the association.
Okay.
And I have had inquiries from a few sheriff's departments, and we'd be happy to, it's not just for the police. We could do sheriffs, but they have their own standards for accreditation for their jails. That's the difference.
I just wanted to bring this up as a point of discussion so that we are proactive. We've had a few incidents that have drawn national attention, but for the most part, our officers do a great job, and we just need to stay ahead of that issue. So I appreciate the discussion.
One thing, many of our agencies now subscribe to Lexapro, and they pretty well keep their policies up, and I think it's made it easier for agencies to meet the accreditation, our Utah accreditation standards, because of that program they're in. And if they need a policy, they go back to Lexapro and they'll get that policy. So it's easier for us to audit that.
What about some of the smaller agencies throughout the state that can't afford Lexipol or even CLIA for that matter?
Well, we don't require any of that. If they want to put someone on their policies, it's just that I think most agencies find that if they don't have some kind of a system to keep their policies updated, it's really tough to keep those policies updated. Sure. It's not the highest priority for every agency all the time.
Okay. Anything else? Sheriff.
Just on the sheriff's side, the Utah Association of Counties has a insurance pool that has been working with the smaller counties, and those that can't afford that, they will offset part or all of that pay to develop and implement the Lexapro. And then whether they go for further accreditation, that's up to them. So at least the standards in having policies hopefully will be done pretty soon throughout the state, even in the smallest agencies. As far as sheriffs, we're working towards working all of those 29 counties into it.
If we had an agency that called us and said we can't afford some kind of a vendor to help with our policies, would you help us? We would.
Awesome.
We'd help you.
And hopefully that's being thrown out there as common knowledge, as a resource for these departments.
I don't know. Somehow they find us. We just really haven't had a lot of takers on it.
It would be nice if we could put some information on our post portal and a link to contact you.
I think we have it on our webpage, but that'd be fine.
Okay. All right. Anything else for me? Thank you.
Thank you, Director. All right, the next item is our disciplinary case review. We'll have Mr. Yonke from the Attorney General's office present.
Good morning, Council. We'll just jump right into it. The first matter before the Council is the certification of Troy Anderson. He was not employed at the time of the incident. Sustained allegations are driving under the influence, which falls under Category D of the post-disciplinary guidelines. Post-recommended disciplinary action is a 2.5-year suspension, and that's based on the high blood alcohol content and previous post-suspension at the time of the arrest. A summary of the facts are as follows. On May 13th, 2013, Troy Anderson was involved in a single vehicle crash and was subsequently arrested for DUI. At the time of his arrest, Anderson's peace officer certification was suspended for a previous DUI, which was scheduled to end on July 8th, 2013. Anderson's BAC at the time, or blood alcohol content at the time of the arrest, was 0.22 grams per 100 milliliters of blood. Anderson entered into a guilty plea to the amended charge of impaired driving, a Class B misdemeanor. During a post-Garrity interview, Anderson stated he could not remember the day of the crash, but said he most likely consumed the alcohol found in his system just prior to the crash. On November 1st, 2014, Anderson waived his right waived his right to a hearing before an administrative law judge and stipulated to the facts as contained in the notice of agency action.
Any questions on this case? Okay, move it for a motion. I'm sorry. Oh, I'm sorry. Mr. Rosen, I didn't know you were here for that case. I apologize.
I appreciate you taking a few minutes or allowing me to take a few minutes of your time. I realize you guys are extremely busy. I just wanted to state that a couple of points of clarification as to me not remembering the crash. I had what was called a traumatic brain injury. I sustained serious injury. I tried to maintain a level of cooperation throughout the entire incident. Secondly, the other thing that I wanted to address was I'm not necessarily lying to myself. I think it was more a matter of being naive to myself. I had stated that I didn't feel like I was an alcoholic, that I had just made a bad choice. Through lots of classes and some meetings, I've discovered that there's different types of alcoholism. And the level where I would fall into would be considered like a binge drinking alcoholic, meaning I don't wake up every day, I don't drink daily, never have, never will. But I fall into a second category, which is oftentimes when I start to drink, I don't know when is enough, when is when, and I have lapses in judgment, i.e. getting on a motorcycle when I'd been impaired. So I just wanted to address those two issues, and I want you to know that I'm taking full responsibility. I have no excuses. I'm not trying to stand before you and make any excuses. I just wanted to clarify those 2 points. I appreciate it. Thank you.
Chair, members of the council, I'm Brett Rawson for respondent. We do not object to or dispute the post recommendation. Ask that you vote to sustain it. Thank you.
Thank you.
Nothing further from post.
Now we'll bring it back to the council for discussion and a motion.
Motion that we accept the recommendation.
Thank you, Commissioner.
Second.
Thank you, Doctor. Okay, we have a motion to accept and second. Is there any discussion on the motion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
The next matter before the council is the certification of Talisha Black, former member of the Tualatin City Police Department. Sustained allegations are assault and domestic violence in the presence of a child, which falls under Category C of the post-disciplinary guidelines. Post-recommended disciplinary action is a 2-year suspension. A summary of the facts are as follows. On April 15, 2014, Talisha Black and her sister were engaged in an argument. During the argument, Black punched her sister in the head with a closed fist. Black's 3-year-old son was present during the altercation. Law enforcement responded and conducted an investigation. At the conclusion of that investigation, the case was screened with the Tualatin City attorney, who declined to prosecute the matter. On April 17, 2014, Black's probationary employment with Tualatin City was terminated. Then on August 5, 2014, Post conducted a Garrity interview with Miss Black. During the interview, Black admitted to punching her sister one time after her sister had punched her. Black said her 3-year-old son was present at the time of the altercation. On November 17, 2014, Black waived her right to a hearing before an administrative law judge and stipulated to the facts as contained in the notice of agency action.
Thank you. Is Ms. Black or a representative here today that'd like to address the council? All right, there is a letter in your packet regarding this incident. Council, take the time to peruse that. Okay, looks like everybody's had a chance to review that, so time for a motion, or if there's further discussion.
I'd make the motion that we accept post recommendation of the 2-year suspension.
Thank you, Sheriff Tracy. Do we have a second?
I'll second.
Thank you, Director Cook. All? I asked it. I learned from the first time. All right, we have a motion to accept and a second. All in favor, say aye. Aye. Any opposed? Thank you.
The next matter before the council is the certification of Jacob Bamey, currently a member of the Logan City Police Department. Sustained allegation is disorderly conduct and a BCI violation, which falls under category E and F of the post-disciplinary guidelines. Post-recommended disciplinary action is a 9-month suspension based on the 2 separate violations. A summary of the facts are as follows. On September 23, 2012, Jacob R. Bamey was investigated by a local police agency for disorderly conduct. Bamey and his estranged wife were involved in a verbal argument in front of the yard of a residence. Bamey's wife contacted the local police and asked them to respond to the residence. Bamey admitted to the investigating officer the verbal argument was loud and involved both he and his wife screaming obscenities. Bamey and his wife were charged with disorderly conduct, a Class C misdemeanor. Bamey later entered a guilty plea, which was held in abeyance to the charge of disorderly conduct. During the internal investigation, it was also discovered Bamey had accessed BCI information for personal reasons. On October 11, 2014, Jacob Bamey waived his right to a hearing before an administrative law judge and stipulated to the facts as contained in the notice of agency action.
Okay, Representative, yes, Mr. Rawson. Very good.
Chair, members of the council, I am Brett Rawson for respondent. We only have one request in this case, and that is that where we have 2 allegations, one being the BCI allegation that we do not dispute, but the other being this allegation of disorderly conduct. It's true that my client did not go to a trial on that allegation. He felt that he did not wish to put the agency in a poor light or his family, and he took what you know as a plea in abeyance. My request, our request for this body is that you detract slightly from the post recommendation of 9 months and you let these sanctions run concurrent such that the 6 months and the 3 months run together so that his entire length of sanction would be 6 months. And we'll stand for questions.
Okay. Any questions from the council? Okay, thank you, Mr. Rawson. Mr. Yaki, do you have a...
Just a brief rebuttal. In regards to post, we feel that the 9-month suspension is sufficient. These are 2 separate incidents. They did not occur at the same time, and so that's why post is sticking with the 9-month suspension.
Thank you. Okay, we have a request to run consecutively. I'm sorry, concurrent. Do we have a motion from the council?
I'll make the motion that we accept the 6 months for the category E. As the
Okay, well, the recommendation is 9 months, so you want to change it to 6 months?
So I'm sorry, I'd like to amend it to 6 months.
Okay, thank you.
I'll second that.
Okay, we have a motion to amend the 9-month suspension to a 6-month suspension, and it's been seconded. Do we have any further discussion? Seeing none, we'll bring it to a vote. All in favor, say aye.
Aye.
Those opposed?
No.
One opposed? Okay, motion carries.
The next matter before the council is the certification of Charles Crosby, former member of the Cedar City Police Department. Sustained allegation is sex on duty, which falls under Category B of the post-disciplinary guidelines. Post-recommended disciplinary action is a 3-year suspension. A summary of the facts are as follows. On March 27, 2014, Charles S. Crosby was administratively investigated by the Cedar City Police Department for engaging in sexual conduct while on duty. On April 4, 2014, during an administrative Garrity interview conducted by the Cedar City Police Department, Crosby admitted to having sexual intercourse with the female while he was on duty. On July 29, 2014, during a post-Garrity interview, Crosby admitted to engaging in sexual intercourse while he was on duty and in uniform. On October 24, 2014, Charles Crosby waived his right to a hearing before an administrative law judge and stipulated to the facts as contained in the notice of agency action.
Okay, thank you, Mr. Yockey. Is Mr. Crosby or a representative here today? Okay, don't see anybody, so we'll bring it back to council for a motion or discussion. Thank you, Colonel.
Second.
Second by Chief Stratton. All in favor, say aye.
Aye.
Any opposed?
The next matter before the council is a certification of Justin L. Curtis. He is a former member of the Cache County Sheriff's Department. Sustained allegations are theft by deception, which falls under Category D of the post-disciplinary guidelines. Post-recommended disciplinary action is a 1-year suspension. A summary of the facts are as follows. During September 2007, while attending a police academy qualification shoot, Justin L. Curtis took a case of .40 caliber ammunition that was left over after the final shoot. During the summer of 2011, Curtis was attending department-sponsored firearms training, and as a range master, Curtis was in charge of bringing ammunition to the range and then returning the unused ammunition to the department armory. At the conclusion of the training, a box of 1,000 rounds of .223 rifle ammunition fell behind some plastic totes in the trunk of Curtis's patrol vehicle. Later, while cleaning his vehicle, he found the case of ammunition placed in a conspicuous location in his garage to remind him to take it back to the armory. And in the fall of 2013, Curtis, being short on money, took both cases to a local pawn shop and sold the ammunition. Some of the boxes had markings from the police academy, and the pawn shop owner contacted the local police department. Curtis participated in his agency's internal investigation as well as a criminal investigation by another agency. Curtis was subsequently charged with 2 counts of theft by deception. Curtis later entered into a guilty plea to 1 count of theft by deception, and the second count was dismissed. On February 5th, 2014, during a post-Garrity interview, Curtis admitted to the theft of the ammunition in 2011, but claimed the ammunition he took in 2007 while at the academy was given to the cadets by the staff. On September 11th, 2014, Justin Curtis waived his right to a hearing before an administrative law judge and stipulated to the facts as contained in the notice of agency action.
Okay, thank you, Mr. Yockey. Is Mr. Curtis or a representative of Mr. Curtis here today? No? Okay. Any discussion on this case?
I'll make a motion to accept.
Okay, we have a motion to accept. I just have to throw in here, I'm sorry, I don't think a 1-year suspension is adequate in this. You take a case of ammunition down to a pawn shop. If every officer did that fell upon hard economic times, we'd be visiting pawn shops a lot. And I think a 1-year suspension for this is just totally inadequate. That being said, I cannot make a motion, but we do have a motion to accept by Sheriff Smith. Do we have a second? Commissioner Gibson? Okay. All in favor of accepting a 1-year suspension, say aye.
Aye.
Those opposed?
Nay.
Okay, we're going to have to do a raise of the hands again. All in favor, raise your hand. Okay, those opposed? Okay, the motion fails. So at this time,
I would make a substitute motion, Mr. Chairman, to raise the suspension to 2 years. I understand from the guidelines it can be anywhere from 3 months to 2.5 years.
that's correct.
I think 2 years would be more adequate. I agree with your comment.
Thank you, Mr. Osborne.
I'll second it.
Thank you, Director Cook. Is there any discussion on that? Okay, we have a motion and a second for a 2-year suspension. All in favor, say aye.
Aye.
Any opposed? 2-year suspension carries.
The next matter before the council is the certification of Brandon G. Doan. Mr. Doan was not employed at the time of the incident. Sustained allegation is falsifying information to obtain post-certification, which falls under Category C of the post-disciplinary guidelines. Post-recommended disciplinary action is a 2-year suspension. A summary of the facts are as follows. On June 9th, 2014, Brandon Doan, a cadet at a satellite academy, submitted an email to Post disclosing his previous illegal use of prescription medication, which occurred in 2007. This information was not on Doan's Post application dated September 18th, 2013, nor was it included in his verification of information on application form dated October 16th, 2013. On June 10th, 2014, Post conducted a Garrity interview with Doan, in which he admitted that he intentionally omitted his illegal use of prescription medication. Doan was concerned that the information would keep him from being admitted into the academy. On October 22, 2014, Doan waived his right to a hearing before an administrative law judge and stipulated to the facts as contained in the notice of agency action.
Thank you, Mr. Yaki. Is Mr. Doan or a representative of Mr. Doan here? Would you like to address the council, sir?
I'd like to thank the council for their time, and I'm sorry that this happened. What happened was 5 years ago, more than 5 years ago, I hurt my back and was on pain medication for the back injury. A coworker offered his pain medications because he no longer wanted them and gave them willingly to me, which I accepted. There was no exchange, and I did not feel at the time that it was unlawful. When I applied for the police academy, I did not feel that I had broken any laws, and then upon a background investigation with Salt Lake County Sheriff's, it became apparent that yes, I had, at which time I notified Post of my actions. I have not concealed this information. I'm not trying to deceive anyone. It was just that I didn't know that I had broke the law.
Okay.
Thank you.
Any questions from Mr. Doan?
On the report here, it says that intentionally omitted his use of hydrocodone. Did you not put the use of it at all on the application, or was it that you had used it but you didn't admit to the fact you'd used somebody else's additionally?
I had a prescription for it, and so it was the same prescription that was given to me. I was just upping the dose because I was in too much pain at the time.
On your application, did you admit that you had used anything? There was no reference to any hydrocodone at all on there, right?
The prescription was wood because it had been 5 years or more.
Okay.
Any other questions? Mr. Yaki?
Nothing in rebuttal.
I'm sorry.
Go ahead, Mr. Doan.
What I am here for is just to ask that there be some leniency in the amount of time that I am suspended on my license, or if you could just suspend my LEO certification so I can keep my BCO and SFO certification so I can still apply for jobs. I have been under investigation for 6 months now and been unable to apply for jobs at that time. I want to get a job in law enforcement, and it is a career path that I've always wanted to do. Thank you.
Okay, thank you.
And just for clarification for the council, when it contains all post certifications when we suspend, not simply an LEO or a BCO, but it would be all post certifications.
All right. Okay. Director or Dr. Budd?
Did you complete the academy?
When I went through under Garrity, I was notified 3 actions could take place: that I could be removed from the police academy. There was a possibility that I would not be able to allow to take the final test, or that they would take my certification. I continued through the police academy, waiting for that decision to happen. I was also notified that I could go before the council in September, but because you guys were down in St. George, I was unable to at that time.
But you went ahead and completed?
I did complete, yes.
Great, any other questions? Okay, back to council for a motion.
I move we accept the recommendations.
Second.
Second by Sheriff Edmonds. Okay, we have a motion and a second. Any discussion? All in favor, say aye.
Aye.
Any opposed? Okay, the motion carries. Thank you, Mr. Dillon.
The next matter before the council is the certification of Sean Hartley. He was not employed at the time of the incident. The sustained allegation is falsifying information to obtain post-certification, which falls under Category C of the post-disciplinary guidelines. Post-recommended disciplinary action is 2-year suspension. A summary of the facts are as follows. On November 10th, 2013, Sean Hartley submitted an application for training and certification with Post. On January 8th, 2014, Hartley signed a verification of application information form, but failed to disclose that he used marijuana in December of 2013. After graduating from the academy, Hartley contacted Post and reported his use of marijuana. During a post-Garrity interview, Hartley admitted to using marijuana in December of 2013 and also omitting the usage from his application addendum in January 2014. On November 17, 2014, Hartley waived his right to a hearing before an administrative law judge and stipulated to the facts as contained in the notice of agency action.
All right. Any questions for Mr. Yockey? No? Okay, is Mr. Hartley here today? A representative for Mr. Hartley? No? Okay, bring it back to the council for a motion.
I move to accept post recommendation of 2-year suspension.
Thank you, Chief Stratton. We have a motion. Do we have a second?
Second.
Your choice, Shauna. You got 3 of them. All in favor, say aye.
Aye.
Any opposed? Okay, motion carries.
The next matter before the council is the certification of Wendy Horlocker. I apologize if Horlocker is what I have. Currently employed with the Utah Department of Corrections and Adult Probation and Parole. Sustained allegation is gambling, which falls under Category E of the post-disciplinary guidelines. Post-recommended disciplinary action is a letter of caution, and this is based on the nature of the offense and the disclosure of the offense by the officer. A summary of the facts are as follows. On or about January 21st, 2014 through February 2nd, 2014, Wendy Horlocker organized a betting pool for the Super Bowl. Horlocker used her state email account to distribute information about the betting pool to those participating. On March 7th, 2014, Horlocker received information from a third party that a department employee alleged Horlocker was abusing her state email account for the betting pool. Horlocker reported the allegation to her supervisor and made a full disclosure of her conduct. An internal investigation was subsequently conducted and resulted in Horlocker receiving a day off without pay. In Garrity interviews with both her department and Post, Horlocker admitted to organizing and participating in the betting pool, as well as using her state email account to distribute the information. On November 18, 2014, Horlocker waived her right to a hearing before an administrative law judge and stipulated to the facts as contained in the notice of agency action.
Any questions for Mr. Yockey? Is Ms. Horlocker here, or a representative like to address the council?
Thank you. I just want to state that I did participate in this gambling pool. It was a Super Bowl pool. And then I later received information that one of my staff members had received a copy of this. Don't know how, but he was going to use it against me as blackmail if I ever tried to hold him accountable. So luckily I was doing training with my supervisor at that time and notified her of the incident and took full responsibility, and I beg for the Post's forgiveness.
Okay, thank you.
Just for post counsel's knowledge, there is a letter in the packet from a chief. So.
Okay. Want to take a moment to review the letter at the end of this packet? Okay, looks like we've all reviewed it. Director Cook, did you want to say something?
Well, I need to recuse myself.
Right, thank you. All right, bring it back to council now for a motion.
Motion to accept the recommendation.
Thank you, Colonel Fuhrer.
I was going to make a substitute recommendation, Mr. Chairman, beforehand.
Okay, do we have to, yeah, we can do that now. We don't have to vote on the first motion. All right, thank you, Mr. Austin.
This one bothered me quite a bit as I read through it. I think this is something that everybody gets engaged in at one time or another, and it seems to me that her real crime here is perhaps using the state email system inappropriately. I think she's been punished enough, and I would make a substitute motion that we take no action.
Okay. We have a substitute motion that we take no action and let the administrative action imposed by the Department of Corrections, APMP, serve as the punishment for this. Discussion on the motion? Do we have a second?
I'll second it.
Okay, a second by Sheriff Edmonds. Do we have to withdraw the original motion? No? Okay. All right. All in favor of the second motion made by Mr. Austin, say yes.
Yes.
It is a social spirit. I want to see.
It's not Robert. We don't care about it.
That's right. And you all passed. Very good. All right. Any opposed? Say no. All right. The substitute motion passes.
The next matter before the council is the certification of Jared Hughes, a former member of the Sandy City Police Department. Sustained allegation is driving under the influence, which falls under Category D of the post-disciplinary guidelines. Post-recommended disciplinary action is 18-month suspension based on the high breath alcohol content. Summary of the facts are as follows. On July 24, 2014, Jared Hughes was stopped by a local police agency for improper lane travel. The officer suspected Hughes was impaired and had Hughes perform the standardized field sobriety test. Hughes showed several signs during the test which indicated he was impaired and was subsequently arrested for driving under the influence. Hughes submitted to an intoxilizer test which indicated he had a breath alcohol content of 0.211. On November 18, 2014, Jared Hughes waived his right to a hearing before an administrative law judge and stipulated to the facts as contained in the notice of agency action.
Any questions? Is Mr. Hughes or a representative for Mr. Hughes here today? No? Okay, back to the council for a motion.
Move to accept.
Thank you. Do we have a second? Second. Yes. Okay, all in favor say aye.
Aye.
Any opposed? Okay, that motion passes. Good.
The next matter for the council is the certification of Zachary R. Hunt. He is a former member of the Department of Public Safety. Sustained allegation is falsifying information to obtain post-certification, which falls under Category C of the post-disciplinary guidelines. Post-recommended disciplinary action is a 2-year suspension. A summary of the facts are as follows. In February of 2012, Zachary Hunt submitted an application to Post for dispatcher certification. Hunt failed to disclose in the application that on 2 occasions in October 2010, Hunt who was then age 17, performed oral sex on a male friend who was age 14. In January 2013, the male friend disclosed the sexual conduct as part of his therapy at a youth substance abuse rehabilitation center. A criminal investigation was conducted, and the case was ultimately adjudicated in juvenile court. In June 2013, the Department of Public Safety conducted an internal investigation to determine the sexual conduct was consensual. During a post-Garrity interview, it was discovered Hunt failed to disclose the sexual misconduct on his February 2012 post-application. On September 15, 2014, Mr. Hunt waived his right to a hearing before an administrative law judge and stipulated to the facts as contained in the notice of agency action.
Okay, any questions, Mr. Yockey? Is Mr. Hunt or Representative Mr. Hunt here today? No? Okay, bring it back to council for discussion or a motion.
I'll recuse myself.
Thank you, Crown.
Move to accept post recommendation.
Okay, we have a motion to accept by Sheriff Edmonds.
Second.
Okay.
Second.
All those in favor say aye.
Aye.
Any opposed?
The next matter for the council is the certification of Jed P. Imlay. He's a former member of the Cedar City Police Department. Sustained allegations are driving under the influence with a minor in the vehicle and leaving the scene of an accident, which falls under Category B of the post-disciplinary guidelines. Post-recommended disciplinary action is a 4-year suspension, and this is based on the nature of the offense and also the high breath
Mr. Yockey,
alcohol.
one moment for a
I
minute.
apologize.
We do not have this case in our packet. Mr. Imlay? It was the email, but it's not here.
1 second.
It's not in your packet.
Correct.
Please go to the next one. We'll get that.
Right, we'll do that. We'll move to the next case, Mark Pruitt. Mr. Yockey, in return of this one, once the council has the information in the packet.
Yes, Mr. Chair. The next matter for the council is the certification of Mark D. Pruitt. He is a former member of the Utah Department of Corrections. Sustained allegation is criminal mischief, which falls under Category E of the post-disciplinary guidelines. Post-recommended disciplinary action is a 6-month suspension. A summary of the facts are as follows. On April 17, 2012, Mark Pruitt and his friend treed a mountain lion using trained dogs. Pruitt waited with the mountain lion while his friend left to pick up another male who wanted to see the mountain lion. When Pruitt's friend returned with the male shot and tagged the mountain lion. According to Utah Administrative Rule R 657-10-2, this action meets the definition of a canned hunt, which they have defined and which is illegal. A law enforcement agency learned about the incident a year later and opened an investigation. On October 18, 2013, Pruitt was charged with aiding and or assisting in the wanton destruction of protected wildlife. Pruitt later pled no contest to an amended charge of criminal mischief. During a post-Garrity interview, Pruitt said that he was unaware that the male intended to kill the mountain lion. In the past, Pruitt's friend had brought others to see the mountain lion, and most took a picture and left. In addition, Pruitt thought the kill was legal because his friend had a valid hunting permit for the mountain lion. On November 19, 2014, Pruitt waived his right to a hearing before an administrative law judge and stipulated to the facts as contained in the notice of agency action.
Thank you. Any questions for Mr. Yockey? Is Mr. Pruitt or Representative Mr. Pruitt here today? No? Okay. Back to council for discussion or an motion. Sheriff?
Can we discuss this for a minute? I got to tell you, some of these wildlife violations to me are so nebulous and so, I mean, it's one of the reasons I don't hunt anymore. I honestly don't know how we're supposed to decipher all of this. He goes and trees a cougar, as I understand it, and then somebody else shows up and shoots the animal, but had a tag for the cougar, correct?
Correct.
A legal tag for the cougar. How in the world is this employee supposed to know, or this gentleman supposed to know that? I don't know. To me, it's very ambiguous. It's very nebulous. I don't know how anyone is supposed to decipher the wildlife code unless you've got the 3-ring binder with you. I just don't know. I mean, we've heard so many of these over the years. I'm just inclined to throw this one out. Is what I'm inclined to do.
Well, and I have a question in that, as I read it, they were out training the dogs. They weren't actually hunting. So to me, that, did they have firearms capable of, killing the cougar as well, or did they just have the dogs? Because I agree with you, Sheriff, somewhat that, this one, to me, is just, it would be hard to know that you were doing something wrong.
Right.
Could I clarify a little?
Sure.
In order to chase cougars, you have to have you get a pursuit tag from DWR. On that pursuit tag, it does specify what you can and can't do, and that if you are actively hunting, the hunter does need to be with the party.
Okay.
So that may clarify a little.
Having,
And I'm sure if he's running dogs and cougars or bears or whatever, I'm sure he had a pursuit tag. I mean, that's not an issue.
So treeing the cougar was not an issue.
Yeah, it's just the hunter wasn't with him, so they detained the cougar in the tree. Cougar won't jump out of a tree unless it has a way to escape. And so they detained it there until they got another person that did have a tag, is what I see.
Mr. Chairman, am I
And that's
allowed
the
to speak to
violation.
this being my case?
I think you can give input, you just can't vote on the matter,
Okay.
Director.
Then the input I would tell you is these folks that hunt cougars, and I'm a hunter myself, know exactly what those laws are in regards to any of these types of things, because it's a little bit more rare. The other thing is that this person did not come forward until the police went to him and cited him for they were actually investigating a whole nother cougar issue. They went to him, and then he reported to us, but he was uncooperative with DNR the entire time. I was a little frustrated with the case, the way it was presented in this one. It's not anyone's fault, but I think I can see why Sheriff Edmonds feels there's not enough information here. From my information, from what I know and what I dealt with in this particular case, a 6-month suspension is very fair based on what we know of this particular person's hunting experience and so on.
So you feel like he did have an understanding of what was going on here?
He did, and it's not his first hunt, and it's not his first time treating a cougar. It's sometimes it's an unfortunate common practice with some of them. That's what they were trying to uncover. Again, this was a sort of a bigger case, and this was a smaller piece of it that they discovered in that regard. So I'd add that 2 cents to it.
Fair enough. I appreciate that.
Sure.
Can I ask a question of the investigator?
Sure. Colonel?
So that brings into some questions. Did he really not know that he was waiting by the tree so some hunter could come and shoot the cat out of the tree? Or was he really thinking he was just sitting there to wait for a friend to come take a look at it?
Again, this would be based on his testimony, which not testimony, but his statements in the interview. That's his statement, is that he did not know. So whether or not that's true or not, I'm just stating that information. And the friend also corroborated that story. That is correct.
Mr. Chair, can I make one more comment? I think it's important to know that they had to go a long distance to get this friend to come and shoot it. That cougar had been treed for an hour to 2 hours waiting for that person to come. So it wasn't like a nearby house. They kept that cougar treed for a long time.
Okay. Thank you. Dr. Budd?
I was inclined to agree with Sheriff Edmonds when I read this case. It sounded like, how would you know? But after hearing Roland's discussion, I would move acceptance of the recommendation.
Well, and with what John said, obviously I've never pursued cougars, so not knowing that you need a permit just to do that, and the rules are clearly stated on that.
Houndsmen their scouts have pretty strict rules.
Okay.
And I also think it would take some time. If a person shows up with a rifle, aims, picks, and shoots the cat out of the tree, there's probably enough time to say, hey, wait a minute, you're just here to take a picture, you're not here to shoot something. So that's why I would move acceptance of the recommendation.
One observation.
Go ahead.
Whatever recommendation this council makes, just make sure you base it on the facts in the action. I know the discussion about the rules and the laws, hunting laws was important, but just make sure it's based on the facts in the notice.
I have a question.
Sure.
Director Cook mentioned that he thought 6 months was appropriate.
I think
the recommendation is 2 years, isn't it? Or am I missing?
If I said appropriate, I apologize. To me, it's very lenient, but.
Okay, any more discussion? Is Mr. Pruitt or a representative for Mr. Pruitt here? Nope. Okay, now we'll bring it back for a motion. I think we probably don't have any more discussion.
I think I've made it twice. So
Yeah.
I'll second it.
Okay. You were just checking to see if I was awake. Okay, we're going to vote by saying yes on this one. All in favor of the 6-month suspension, say aye.
Aye.
Any opposed? Thank you.
Chairman, I didn't get who seconded that.
Mr. Conley.
Okay.
Or Crowley, sorry. Conley. Okay, we all have the Imlay case before us now. Mr. Yockey, if you'd like to go back to Jed's case, we'll consider that now.
Okay, so the next matter is the certification of Jed P. Imlay. He is a former, as previously stated, he is a former member of the Cedar City Police Department. Sustained allegation is driving under the influence with a minor in the vehicle and leaving the scene of an accident, which falls under Category B of the Post-Disciplinary Guidelines. Post-recommended disciplinary action is 4 years, and this is based on the high BRAC and also the nature of the offense. Summary of the facts are as follows. On June 2nd, 2014, Jed Imlay drove his Cedar City Police Department patrol vehicle to a local baseball park with his minor son in the vehicle. Imlay struck a retaining wall at the baseball park with his patrol vehicle before his son exited the vehicle. Witnesses observed Imlay get out of the patrol vehicle and exhibit behaviors of intoxication. Shortly after, Imlay struck the wall, got back into his patrol vehicle, and left the scene. The Cedar City Police Department was notified of the accident, and an investigation was conducted. Both the criminal and department administrative investigations later determined Imlay was under the influence of alcohol at the time of the accident. Imlay was later arrested for driving under the influence with the minor in the vehicle and leaving the scene of the accident. On October 28, 2014, Imlay pled guilty to DUI, a Class A misdemeanor, and the second charge was dismissed. Jed Imlay was sent a notice of agency action but failed to respond accordingly, and on November 6, 2014, an order of default was signed by the administrative law judge and mailed to Jed Imlay.
Okay, is Mr. Imlay here, or a representative for Mr. Imlay? No. Okay, back to council for discussion and a motion.
Make a motion, we accept the 4-year suspension.
Thank you, Mr. Crowley. Do we have a second?
Second.
Thank you, Mr. Austin. All in favor, say aye.
Aye.
Any opposed? Okay, now that brings us to our last case. Mr. Yockey.
Last matter before the post council is the certification of Robert R. Randell. He is a former member of the Tuala County Sheriff's Office and also the Salt Lake City Police Department. Sustained allegation is assault and lying under garrity, which falls under Category A of the Post-Disciplinary Guidelines. Post-recommended disciplinary action is revocation. A summary of the facts are as follows. On August 13th, 2013, Robert Rundell was dispatched to a residential burglary. The suspect was arrested nearby by a second officer. Rundell arrived at the suspect's location where the suspect was being questioned and searched. Rundell engaged in a conversation with the suspect, which resulted in Rundell striking the suspect in the face. Rundell later told his supervisor he slapped the suspect for a little bit of remembrance. In Garrity interviews with the Salt Lake City Police Department and Post, Rundell denied slapping the suspect. Instead, Rundell explained when the suspect made a move towards his gun side, Rundell checked him to the jawline to gain a little bit of compliance and control. On September 18, 2014, a hearing was held before an administrative law judge. The ALJ subsequently issued a finding of facts and conclusions of law stating that Officer Robert Rundell violated Utah Code Annotated 53-6-211 as outlined in the Notice of Agency Action.
Any questions, Mr. Yaki? Is Mr. Randell or Representative Mr. Randell here? No? Okay, bring back council for a discussion and a motion.
Teach the check and redirect slaps anywhere in Post, do we?
Not in years.
I'm not sure you come up with that, huh?
They probably taught that in the academy when you went through.
Fair enough.
I think we carried saps and Kel-Lite flashlights back then too. Okay, we have a motion by Sheriff Smith to accept.
I'll second.
And Mr. Austin seconds. All in favor, say aye.
Aye.
Any opposed? Motion carries. Thank you, Mr. Yaki.
Thank you.